Hi, I'm Guy Relford from Tactical Firearms Training LLC and from the law offices of Guy Relford in Carmel, Indiana. And this is episode 1 of the Guns and Ranges feature of the Indiana State Rifle and Pistol Association and their new website. So we thank you for tuning in today. What I'm going to talk about is the essentials of what you need to know before you carry a firearm in self-defense. And we're going to assume for purposes of this discussion that you've had the basics, that you know basic firearm safety, that you can recite and follow the 4 rules of firearm safety, that you know how to store your gun responsibly, which is to store it so it's inaccessible to unauthorized or untrained people. We're going to assume that you have the basics of marksmanship and that you can generally hit what you aim at. A lot of times people stop there. They have a basic pistol class, even an 8-hour class, which I teach at Tactical Firearms Training. And that's great, and that's essential, and that's necessary for you to be a responsible gun owner, but it doesn't answer the question of all the things you need to know before you're going to carry a gun for self-defense. There's a lot more out there that a lot of times people don't know they don't know. And that's some of the things that we're going to talk about briefly. Now, I teach a full 6-hour class along with Tony Gregory, who's the lead instructor at Indy Arms Company, and we teach a 6-hour class called The Fundamentals of Armed Self-Defense. So in just a few minutes today, I'm going to cover some of those things that we cover in depth in 6 hours at Indy Arms in our Fundamentals of Armed Self-Defense course. But here we're going to give you a bit of a heads up of those things you ought to be thinking about if you're going to carry a gun for self-defense. The first is, do you know when you can pull that gun out of the holster and point it at someone? Pointing a firearm in Indiana is a crime. And if it's a loaded firearm, it's a level 6 felony. A lot of people carry guns every day and they have no idea that it's actually a crime to point a gun at someone unless you're justified legally in pointing that gun. There are limited circumstances when you are. One is if you're actually effecting a lawful citizen's arrest, which you can do if someone's committing a felony in your presence. Another is if you're justified in using deadly force in self-defense. And of course that makes sense because if you're justified in using deadly force, in other words, shooting someone, you must be justified in pointing your gun at them as well. But if you don't fall into one of those categories, for instance, we have a case in Indiana very specifically on point that says that pointing a loaded gun at someone creates a substantial risk of serious bodily injury. That's the definition of deadly force. And we have a statute in Indiana that says you can never use deadly force merely to protect your personal property. What that tells us is that, and as the Indiana Court of Appeals has told us very specifically, you can't point a gun at someone merely to defend your personal property. Now, I'm not talking about your home. I'm not talking about the castle doctrine. I'm talking about your stuff. You can't point a gun at someone merely to defend your stuff, your personal property. A lot of people don't understand that. They're carrying guns every day, but they don't know the rules of when they can pull that gun or when they can point that gun. The other thing you absolutely need to know is when you're, as I mentioned, when you're justified in using deadly force in self-defense. When are you justified in using deadly force in self-defense in Indiana? There's 4 discrete specific circumstances. If you're protecting yourself or a third person from serious bodily injury, and that is you have to reasonably believe that deadly force is necessary to protect yourself or a third person from serious bodily injury. You can also use deadly force to prevent the commission of what we call a forcible felony. Now, that's not any felony. It has to be a forcible felony. And we define forcible felony as a felony that involves a substantial risk of serious bodily injury to a human being or a felony committed through the use or threat of force. Okay, there are a lot of felonies that aren't forcible felonies. Stealing your car is a felony. But unless you're in it and it's a carjacking and you get threatened, then just stealing your car out of your driveway when nobody's in it, that's a felony, but it's not a forcible felony. So you would not be justified in using deadly force under those circumstances. So to prevent serious bodily injury to you or a third person, to prevent the commission of a forcible felony, then what we call our castle doctrine is if you reasonably believe that deadly force is necessary to prevent or terminate an unlawful entry into or attack upon your dwelling. Okay, that's the castle doctrine. If you reasonably believe that deadly force is necessary to prevent or terminate an unlawful entry into or attack upon your dwelling. Now we go on to extend the castle doctrine to also prevent, to use deadly force to prevent a attack or unlawful entry or attack into your curtilage, which is really largely undefined in Indiana. We don't have time to go into that issue in this video today, but that's generally the livable space immediately outside the walls of your home where you have an expectation of privacy and where normal domestic activities occur. Where is that exactly? We don't really know because we don't have a case that tells us. But the counsel doctrine also extends to an occupied motor vehicle, to your occupied motor vehicle. So you're allowed to treat your occupied motor vehicle just like your home in terms of the castle doctrine. And you can use deadly force to prevent or terminate an unlawful entry into or attack upon your occupied motor vehicle. Now again, just stealing your car out of your driveway with nobody in it wouldn't fall within this area of the law of self-defense in Indiana. And the fourth time you can use deadly force in Indiana is to prevent the hijacking of an airplane. Well, I think we all have figured that out, certainly since 9/11. I think my 87-year-old mom is going to be attacking a hijacker of an airplane knowing there's no other option. But Indiana law specifically justifies the use of deadly force against a hijacker. But it doesn't end there because, okay, knowing when you can draw your gun, when you can point your gun at someone, or even when you can use deadly force, doesn't end what you really need to know to be prepared for instance, the aftermath of an armed self-defense encounter. Okay, you've now shot someone. Someone's been in your home. They broke into your home. It was absolutely a justified shoot. No question about it. And you've had to defend your home, defend your life, defend your family with deadly force. Well, what do you say to 911 when you call? Okay, there's a whole discussion about that we go through in detail. Tony Gregory and I do in the Fundamentals of Armed Self-Defense course. But essentially what you should tell 911 is the minimum of what you need and where you need it. You need police, you need an ambulance, you need the address, and a short description of what happened. He broke in, I had to defend my life, and really leave it at that, because what you need to understand is that you're going to be completely amped up on adrenaline. You may be suffering the emotional after effects that can range from euphoria because you're alive, because you survived the encounter, to remorse, to feeling horrible about having just taken a human life, which most of us will feel. You don't know how you're going to be reacting both physiologically due to the effects of adrenaline as well as emotionally or psychologically because of the traumatic event that you just survived. And since you're going to be in emotional and physiological no man's land, that's not a time to be giving a detailed description of what happened. You're going to leave things out. You're going to remember things incorrectly. You're not going to do a good job of giving a detailed statement. So you want to keep things to a minimum on the 911 call, what you need and where you need it. Make sure that you get the location correct. A lot of times if we're upset, we're emotional, we're pumped up on adrenaline, it's easy to transpose a couple of numbers and an address. A lot of times we even recommend someone have their number written down near the phone you may likely have to use in your home to call 911 just to make sure you get that address correct, because if you send an ambulance, you send the police to the wrong address, that does no one any good. But then you also need to know how to respond when those officers show up, because the officers are going to want to know what happened and they're going to push you to talk. And the best response you can give, and this is counterintuitive, and it's against anything we're going to want to do under the circumstances. Because if we're justified, we're completely lawful in defending our homes, defending our lives, we're going to want to say that. We're going to want to describe that. We're going to want to describe exactly what just happened to those police officers. And intuitively, we're going to think, well, there's no downside to doing that because I was in the right, and the police officers on our side. Well, they are on our side. I absolutely believe that. But you also have to understand that you're not going to do a good job of giving your statement when you're amped up on adrenaline, when you're suffering those emotional effects that we just discussed. So there are any number of things that you're just not going to do well on if you give a detailed statement at that time. You're going to regret having said a lot of what you said. Some of it's not going to be right. Some of it's going to be excessive. Some of it's going to be driven by either adrenaline or the emotional effects, and you're not going to do a good job. That's why police officers are under standing orders. Virtually every department I've ever talked to, and I've talked to a lot because it's part of my job, they're under standing orders to not give a statement if they're involved in a shooting. Most often for 3 sleep cycles, meaning 3 days essentially before they're supposed to give a statement with legal representation present, and if it's a union department, with union representation present. That's what the police are told to do. If that's what they're told to do, that's a smart thing for us to do too. So a perfectly reasonable response is to say, officer, I'll be glad to cooperate fully and give you a full statement once my attorney is present and I've had a chance to calm down. That's a reasonable thing to say. It's the best thing to say because you're not going to say something you will later regret or that may later even be used against you as if you've committed a crime when what you've done was absolutely legal when you did it. So don't do anything at the scene driven by emotion or driven by adrenaline that you and your attorney may regret later on. So I'll be glad to cooperate fully and give you a full statement after my attorney is present and I've had a chance to calm down. That's the best thing to say. And no officer is going to really believe in his or her heart that that's an inappropriate thing to say? Because that's what they've been told to say. They're not going to tell you that on the scene, and they're going to push you to talk. And they may say things even like, well, I'm going to think you're guilty if you don't talk to me. Or I'm going to have to write something in my report. Do you want me to write self-defense or murder in my report? Don't you think you want me to write self-defense? Well, you better talk to me. The answer is, I'll be glad to cooperate and give you a full statement after my attorney is present and I've had a chance to calm down. That way that statement's going to be as accurate as possible, and that's what you want when you've been justified in using force in self-defense. The other thing to know right up front is that the aftermath of a deadly shooting, even if you're 100% justified, and even if the prosecutor's office never thinks for a moment about prosecuting you because the shoot was a lawful shoot, a lot of bad things still happen. You can get vilified in the media, including social media. Depending on the circumstances, you can be called a lot of different names. You're bloodthirsty, you're a racist, depending on the circumstance. People can say because you carry a gun or own a gun, you were looking for this from day one, so it's all your fault. People will cast blame upon you, and you can be vilified publicly. You may very likely get sued. Even if there are no criminal charges, you can still be sued in civil court. And we've seen examples of that. A former client of mine, Elijah Elliott, who was the assistant manager at the Kroger at 71st and Georgetown in Indianapolis, was absolutely justified in killing a robber who came into that store. Marion County Prosecutor's Office never thought for a moment about bringing criminal charges against Elijah because it was a justified shoot. He killed a robber in self-defense. Absolutely, it was a forcible felony. He was defending himself and other employees from serious bodily injury, and it was 100% justified. 2 lawsuits were still filed against Kroger and another against both Kroger and Elijah, claiming damages, one from the mother of the armed robber, as ridiculous as that sounds, and the other, even more ridiculous, is the armed security guard, the unarmed female security guard who was getting herded back into an office for who knows what reason. She sued Elijah and Kroger, saying she was emotionally traumatized because Elijah had used deadly force in her defense. She still filed a lawsuit. So a lot of bad things can happen, even if you're completely justified legally in shooting. That's why we always teach, and in fact I preach, that deadly force always ought to be a tool of last resort. You'll hear that in every responsible course that you ever take, taught by a responsible instructor, that even if you're justified, it's really an act we want to avoid if we possibly can. And that's a breakdown and a summary of what you need to know if you're going to carry a gun in self-defense. I'm Guy Relford from Tactical Firearms Training, LLC. You can see that website at tactical-firearms.com, and also my legal practice, where we practice exclusively in the area of Second Amendment-related issues. You can find that at relfordlaw.com. Thanks for being with me today.